Let's quickly go back to the Bloemfontein High Court, where the court just heard an application that has been brought by Dr. Nandipha Magudumana for an application for leave to appeal a Bloemfontein Magistrates High Court ruling, or the Bloemfontein High Court ruling rather. This is in relation to the Thabo Besser escape matter, where Dr. Nandipha Magudumana wants to argue in the court that the decision that was taken to deport her was unlawful, and also remember that the court also found that it was a disguised extradition. Let's quickly speak to our reporter, KAMOGELO SEEKOEI. KAMOGELO, good morning. Thank you once again for making time for us. So what did we hear in this application?
Well, Aldrin, we heard from Dr. Nandipha Magudumana's legal representatives this morning, of course, expressing what is contained in their heads of argument, that the process to bring back Dr. Nandipha Magudumana back to the country was actually unlawful and it was illegal. They are saying that they told Judge Lobsha that it is in the interest of justice to have to grant Dr. Magudumana her leave to appeal and to take the matter to the SCA. They did say to the judge that the process was illegal, and that is the reason why they want the SCA to test the legality of that process that brought back Dr. Nandipha Magudumana back into the country. We also heard from the Department of Home Affairs as well as the South African Police Service, who are of course opposing this application to grant Dr. Nandipha Magudumana leave to appeal. But I have with me her legal representative, Machini Mutlou, who I would like to bring into the conversation, just unpack for us what is it that you actually want the SCA to look at, where should this matter be, this appeal be granted?
Issues that we are raising are quite succinct. That one, the court found that the extradition, which, by the way, SAPS and DHA have always been, insistent that it is lawful, but the court has found that extradition, actually it was a deportation according to them, but the court found that it was a disguised extradition. Now, the only point which the applicant seeks ventilation and proper ventilation at the SCA is whether the court was correct in sort of saying she consented to the deportation or to an illegality, because we are saying that if the court found the extradition to be disguised, that is an unlawful act, that is illegality. The argument that we are presenting here is, can anyone consent to an illegality? But of importance as well is, can this be seen to be consent within the parameters of the law? Was this consent informed? And in this instance, I think our counsel eloquently outlined the requirements that has to be fully satisfied for a consent to be deemed to be informed.
We heard from counsel from South African Police Service saying that, insisting rather, that consent was given and the buck stops there essentially. What are your impressions about that?
Look, even to this date, bizarrely, this consent is given to all and sundry. Is it not tantamount to giving consent to whom it may concern? We still don't know who this all and sundry is or are. It would seem that the applicant was on a loud hailer, just telling everyone that I want to go home. That is precisely a crisp legal question, which we are of the view that the Supreme Court of Appeal will be in a position to respond to, and the Supreme Court of Appeal may reason differently around this question.
The judgment is reserved until Tuesday. What are your expectations?
And look, we launch We launched an application for leave to appeal. We still of the view that leave must be granted so that the SCA should really ventilate on a whole range of legal questions emanating from our application for leave to appeal. In our view, we would really want this matter to be heard at the SCA until the 18th of July. By the way, that will be Madiba Day. So let's see. We remain hopeful and we remain optimistic that the outcome will be in our favor.
Let me take you a little bit back to yesterday. Your client received a visit from the Commissioner of Correctional Services. Firstly, did you know about that, and what are your impressions?
Look, we didn't know about that. We're quite dismayed, particularly having heard the reasons for such visits. Of course, one heard that this was more of a routine visit, but when one looked deeper into it, it was triggered by some, media reports on favoritism and other, treatments and conditions upon which our client is seen to be, staying. And our view is these issues ought to have been canvassed with the legal team so that we are fully aware of the visit, we are fully aware of the reasons why the commissioner had to go there. But we will be consulting with our client this afternoon, and we'll get more information and instructions on exactly what transpired during that visit. But for the department to react to each and every allegations in the social media, and some of these allegations are sporadic in nature, I believe that proper investigations on such allegations need to be done first, and with proper notification to the legal team. And this was not done, and we are quite dismayed regarding such conduct of the department.
Thank you so much, Mr. Muklong. That was Machini Muklong there, just summarizing for us their arguments that they presented in court today regarding their application for leave to appeal in the matter involving Dr. Nandipha Magudumana. Dr. Nandipha Magudumana, of course, brought an application to the court to get her arrest in Tanzania declared unlawful. Judge Philip Lobsher did find that the process followed to bring her back here was unprocedural, but on the basis that she consented, he then dismissed that appeal. And today we were here to hear another application to challenge the verdict that Judge Philip Lobsher issued in this court. He did postpone the matter to Tuesday, when he will be granting his judgment in the matter. It's back to you in studio.
Thank you so much, KAMOGELO SEEKOEI there.